It is Saturday, and I am in the office getting things ready for another busy week for our law firm in Pennsylvania and New Jersey. I'm supposed to begin a trial in Bucks County, Pennsylvania this week. So hopefully that's going to go very well for our law firm. I'm very confident in our case for the defense, and I believe very strongly that our client will be exonerated during that trial. With that said, I did come out with a blog article today regarding fingerprint evidence and illegal guns and firearms. And this is a very, very important topic because I can't tell you how many of our clients come to us with questions about fingerprints, and a lot of them believe that because the prosecution is unable to present fingerprint evidence in a particular case, they cannot be charged with a crime and certainly not convicted of a crime. That is simply not the case. As I detail in that article, it is very difficult often to obtain fingerprint evidence from guns and firearms and a lot of surfaces. And frequently the prosecution won't present fingerprint evidence. Now, if it doesn't present physical fingerprint evidence, obviously the defense can point that out. But the assistant district attorney or the prosecutor in the case of New Jersey, if they know half of what they're doing, will normally present some type of counter argument to that defense argument, normally an expert to testify as to why fingerprint evidence was obtained. And that has to do a lot with the fact that the gun or the firearm has certain types of oils and the surface itself was perhaps dirty, and they couldn't pull a fingerprint off that particular weapon. Now, with that said, the prosecution can still establish the illegal possession of a gun or firearm in Pennsylvania and New Jersey through a constructive possession theory. Remember that the fact that police do not find the gun or firearm on your person doesn't mean that you can't be charged with it. So with regards to constructive possession, they can argue that the gun or firearm was in your area of immediate control. For instance, if it's found certainly in a vehicle underneath a seat and you're the only one in the vehicle, that's a very, very strong theory of constructive possession. If there's people in the vehicle with you, that theory, that prosecution theory becomes less perhaps credible, because we can argue on the defense side that other people in the car could have constructively possessed that weapon. With regards to homes or residences, again, prosecution will normally present, in addition to that gun evidence, some type of evidence connecting the person with that firearm. Usually, if it's a residence, they're looking for a piece of mail or perhaps personal items in that area where the weapon was found. That is known as constructive possession. Obviously, they can also use other forms of circumstantial evidence to prove their case beyond a reasonable doubt. As all of my readers and my viewers of my videos and my blogs know, that the burden of proof in any criminal case, whether it be in Pennsylvania or New Jersey, is guilt beyond a reasonable doubt. It is a much higher standard than the civil court, which is just the preponderance standard. We're seeing that now in the Deshaun Watson case. The grand jury did not return an indictment. I remember that a grand jury, it is not guilt beyond a reasonable doubt. It is a preponderance standard. And now, since the criminal case is no longer being pursued, the civil case, however, is still viable. And I do believe that they more than likely will achieve some type of settlement for those plaintiffs in that case. I don't believe that Mr. Watson wants to go through hours and hours of deposition, and certainly not go through a very public and very perhaps costly trial where a jury could return a very bad verdict for him. And I'm pretty confident that if the case went to trial, he would more than likely be found liable of some pretty serious allegations and possibly open himself up to even more of a suspension from the NFL. So I think that case will be settled. I'm jumping off a topic here, but getting back to fingerprints. With regards to fingerprint evidence, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, the website gamboandlaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. You can also sign up for our e-update, which goes out each and every Friday to over 4,000 of our current and former clients in Pennsylvania and New Jersey. It is a great resource to have going into the weekend. But once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Remember, the best time to hire an attorney is as soon as you're arrested. Don't wait on that. Remember, never assume that bail is not going to be an issue, because Pennsylvania and New Jersey have very, very different bail systems. Remember, in New Jersey, we have a cashless bail system, and in Pennsylvania, it is still a cash-based system. So once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Have a great Saturday. It is a beautiful day. I hope to enjoy it soon. I'm still in the office knocking out some work, but I'll talk to you all very soon.